Rise. We'll come to order.
You may be seated. Let the record reflect that the defendant is present along with counsel for the defendant. Assistant State Attorneys, both sides ready to proceed.
Yes, subject to previous motion.
State's ready, Your Honor.
All right, let's return to jury.
All rise, jury entry.
You may be seated. State recognizes the presence of the jury.
Yes, Your Honor.
And does the defense.
Yes, Your Honor.
Good afternoon, members of the jury. Did you follow all of my previous instructions? You may proceed with your cross-examination.
Good afternoon, Dr. Pritchard.
Good afternoon, sir. How are you?
I'm doing well, thank
Good.
you. Now, Dr. Pritchard, you would acknowledge that reaching an opinion in this case was difficult.
Yes.
And in fact, you called it an extremely difficult case. Would you agree with that?
Yes.
Indicate that the defendant, Jason Rodriguez, may have understood that his actions were wrong.
Well, ultimately, that is not what I said, but there were variables involved in the case that made it extremely complex, and some of the variables weighed on the side of, yes, understanding it was wrong, but the bulk of the information for me weighed on the side of not understanding it was wrong.
Okay. So let's talk about some of those variables, if that's okay.
Okay.
For instance, as one of those variables that indicated Jason Rodriguez knew it was wrong was the fact that the vest he was wearing was not found,
Yes.
and the fact that the magazines and the firearm that he shot that day were not found.
Yes.
And did it also make it difficult because he couldn't tell you where they went, or wouldn't
Yes.
tell you where they went?
Yes. I mean, the suggestion was that perhaps there was some hiding of evidence, and typically when that occurs, it is suggested that the individual knew that what he was doing was wrong and therefore hid the evidence.
Okay. Would another one of those facts be that he reloaded? And by that I mean changed magazines during the course of the shooting.
I don't think for me that would provide weight on the side of knowing it was wrong.
Okay. That he came to the window when the SWAT team arrived and put his hands up.
Yes.
That he told law enforcement officers that he was going through a difficult time and that he was sorry when they approached him after the incident.
Yes. Again, when you say I'm sorry, the tacit suggestion is you recognize you've done something wrong.
And Dr. Pritchard, was
Just a
there...
second. Doctor, speak up a little louder so they can hear you. Thank you.
Yes.
Yes, sir. Was there evidence that the crime had a financial motive?
Yes, there was commentary from Mr. Rodriguez to police officers that there were some financial issues and burdens created by his difficulty with keeping a job and with getting a unemployment check. So yes, it appeared so.
And commentary from him that he blamed RS&H for that, at least in some form or fashion, some way.
Yes.
Okay. Now, I want to go to the fall of 2009, because you've stated that insanity is a key issue at the time of the offense, correct?
That's correct.
And you stated in your report, and I believe here, that there was very little information regarding Jason Rodriguez's mental state throughout August, September, October of 2009. Would you agree with that?
I would, yes.
And I believe you also stated that you relied upon his mother primarily for the information about his mental state for that 3 months.
That's correct.
So, in other words, in layman terms, what she told you filled in that gap as to what he was thinking and doing during that time.
Yes, I mean, provided me with some information suggesting that clinical symptoms were present. Certainly it wasn't all the information about what had occurred during that 3-month span, but clinically what I was trying to determine from Mrs. Rodriguez is whether there appeared to be symptom manifestation of mental illness, mental infirmity, disease, or defect that remained active at that time.
And you indicated that that was a concern for you because it's his mother.
Yes, and not just in this case, but again, my experience has been that sometimes families provides the least reliable information. Sometimes they provide very good objective information, but often it's not very good.
Was there anything to lead you to believe that you reviewed that they did not have a good relationship?
No, it seems as if they had a good relationship, that he was quite dependent on her for a number of things, in fact lived with her, so it sounds like she was very supportive of him, and that he depended on her for quite a few things.
And there's nothing to indicate that she wouldn't be supportive when she was talking to you about what she saw, supportive of her son.
Yeah, I mean, that's the issue, right? I mean, what did it seem like she was kind of piling on and just giving positive information and perhaps information that was not legitimate in describing his behavior, or did it seem like she was describing behavior, as I referenced earlier, that some of it she probably wasn't aware that she was likely describing symptoms of a mental illness, but she was, for example, putting the headphones on to not hear the voices.
Okay. Now, you are aware that she had had her son Baker acted in the past, correct?
Yes.
So you would agree that she had knowledge of symptoms that he had experienced in the past?
Yes, with the qualification that psychiatric symptoms can be pretty vast. I know in the 2007 Baker Act commitment, part of the reason, her stated reason for the Baker Act was suicidal ideation, so thinking about suicide. So she had some familiarity with some of the symptoms and some of the peculiarities involved in his particular mental illness, and there seemed to be some indication that some of the behavior she reported, she wasn't sure why he was doing it and wasn't sure if it was related to a mental illness or not, which was clinically valuable to me. Was doing it and wasn't sure if it was related to a mental illness or not, which was clinically valuable to me.
Okay. At least that's what she told you. She wasn't sure. She was just kind of giving you everything that she says she saw.
Well, yes, and with my prompting, tell me some of the behaviors you were concerned about, and that's when she provided the information about the behavior she was concerned about.
Now, Dr. Pritchard, do you know if you were the first doctor she had talked to about this?
I do not know.
And specifically, I believe you said that you reviewed the sanity report from Dr. Olander.
Yes.
And in that report, it indicates that she had contact with Ms. Lopez well in advance of September of 2013, correct?
Yes, I was going to say my recollection was that Ms. Rodriguez said that she had talked to other mental health professionals too.
So you weren't the first person that she gave information of this nature to. Would you agree with that?
I would agree with that.
Okay. Now, did you have any indication from her as what she was doing the day of the shooting, the morning of the shooting?
Just the relevance.
Goes to her credibility.
Overall.
Thank you, Your Honor.
Yes, my recollection, as she reported, was that she was concerned about her son because some things that had happened, and she was planning on Baker acting him, but she didn't have her phone. She couldn't find her phone.
Okay, so she told you that she couldn't find her phone that morning.
Correct.
Did she ever indicate to you that she never had an opportunity to seek assistance? And I'm not trying to trick you. If you want to refer to page 9 of your report is what I'm looking at. And it's the top paragraph. Please take your time.
I didn't think you were trying to trick me, so thank
No,
you
no,
for thank you
just
for
looking
guiding
at
me.
it. Of course.
Okay. Would you repeat your question for me, please?
Sure. Maybe it was inartfully worded. Did she ever indicate to you that you recall that she had time with her phone to seek assistance?
My recollection is, yes, that after she found the phone, she left the apartment for the specific reason after her son, Mr. Rodriguez, came home after the RSNH shooting. She was not aware of it at the time, obviously, but she said she had found her phone and was leaving so that she could make some contact with mental health professionals.
Did she talk to you about having a phone conversation with an attorney that morning?
I don't think she did. I went over the notes that I took with my interview with her, and I don't remember her saying anything about a conversation with an attorney.
So your recollection of her statements is that she didn't have her phone or any opportunity to tell people what she saw until she was contacted by law enforcement at the grocery store. Does that sound right?
Almost. She was leaving the apartment to make contact with mental health professionals is what she told me. She parked in a parking lot, and that's where officers made contact with her.
Did you follow up on, I guess the question was answered, that she didn't have her phone is what she told you. That's why she couldn't.
Earlier, yes, and then she said she had found her phone.
Would it give rise to concern about her credibility if she did have the opportunity to make a phone call that day?
Objection, Your Honor, improper opinion.
Sustained.
Move on. Now, did you ever, I'm going to turn now to speaking about your conversation with Mr. Rodriguez.
Okay.
Did you ever discuss with him his visit to the post office?
Yes.
And did you discuss with him whether or not he was carrying a firearm there?
Yes.
Do you recall what he told you in regards to taking a firearm to the post office?
He didn't do it because it was illegal.
Okay. And what about going to the school? I remember you talking about going to the school. Is that right?
Correct.
Do you remember if he said anything about carrying a firearm into the school?
He did not because it was improper. It was illegal.
Okay. How did that affect your thoughts on his mental state the day of the offense, that he didn't take that firearm?
Well, it's an issue. It's an issue. It seems, on the one hand, he knows that it's wrong to take a firearm in the post office and onto a school campus. On the other hand, how can you say he didn't know it was wrong to go to RSNH with the firearm and shoot people? My response to that is that the RSNH people, Mr. Velazquez and company, they were the subjects of his delusional system, of his psychosis. It had nothing to do with people at the post office box. At the post office. It had nothing to do with the people at the school campus. So for me, clinically, when I'm trying to piece this together, the thought is that he made a decision that he was being persecuted to the point where he couldn't even get an unemployment check, and made a decision to do what he did because he was being persecuted. And that was kind of the straw that broke the camel's back. So at that point, he was going to eliminate the persecutors, and he was going to do it with a gun. So it was the post office people and the school people had nothing to do with his delusional system.
Okay. So it's not that he thought he was in danger? And the reason, if I may, Doctor, that I ask that is because you're saying that he went there to eliminate people with a gun. Is that what you're saying?
Yes, sir. And keep in mind, this is extremely complex. It's not simple. So I'll try to articulate it as well as I can. Yes, persecuted, and his life was in danger. He had expressed that. He had expressed that for a couple of years since the firing. And again, remember, RSNH had nothing to do with Mr. Rodriguez. But in his mind, that's what kept coming up. They're harassing me at my job at Subway. They're harassing me at my job at Orange County Public Works. People at RSNH are responsible for this. Mr. Velasquez is responsible for this. They're manipulating numbers so I can't get my unemployment check. And communicating with the FBI and FCCC and making some of these kind of urgent pleas for assistance. So, and I think that was ultimately the incident that was the straw that broke the camel's back in terms of him being persecuted by these people.
He felt angry enough to go there and take care of the problem.
Well, anger is an element in it. You can be insane and angry. The issue is what he's angry. Why? What is the motive for the anger? Is it simply that he didn't get a unemployment check and he holds RSNH responsible for that? In my mind, clinically, no. It's not simply that. It's a product. The anger is a product of the expression, they are destroying my life. I'm in danger. The people I love are in danger. They're creating they're sending me emails that are inappropriate. They're sexual in nature. They're following me. It's all of this and culminating in not only no job but no unemployment check, and him believing that the numbers are being manipulated, and that is why he's not getting an unemployment check.
Well, Doctor, and now I'm referring specifically to page 14 of your report, where I believe you indicate that your opinion, that he truly believed his life was in danger, and that's why he didn't know what he was doing was wrong, in your opinion.
Yes.
Okay. And sort of acted in self-defense. Would you agree with that? Based on what you're reviewing in your opinion.
Right. Self-defense, preemptive strike. Preemptive strike. This is a process in his own mind, and you have to consider that this is in his mind. It is that this is a process of victimization by these people, destroying aspects of his life slowly, egregiously, brain hacking, manipulating other employers so he can't hold a job. So yeah, his life was in danger. They were slowly destroying it. Not somebody from RSH came in and had a gun to his head that immediate moment, but a process of destroying his life, yes.
Okay, so there's no indication to you that he was in imminent danger at any point the day of the shooting?
No, I mean, here in reality, absolutely not. He was not in any kind of imminent danger. In his own mind, in his delusional system, yes, I think he believed he was in danger.
So, Doctor, to be legally insane, his delusions, even if true, would have to justify the act that he did, correct?
That is one way to look at it, yes.
Okay. So, To be justified to use deadly force like that, he would have to be in imminent danger, correct?
Well, I mean, I think that's not,
That's a legal conclusion.
I mean, what I would say is that's not really my opinion. That's not, if you're asking my opinion, I can give it, although
No.
I think that's the jury's decision.
Let me be clear about what I'm asking. Is you rendered an opinion that he acted in defense of himself, and that's why he didn't know it was wrong, correct? Wrong to shoot 6 people.
No, that's correct. It's a simplified version, but yes, that's correct.
Okay. And what I'm saying, or what I'm trying to ask you, I guess, is he would need belief that he was in imminent danger to use the force that he used. And you just said that at no point was there a fact that led you to believe he was in imminent danger.
Well, I mean, I think it's a difficult question to answer that when put that way. An imminent danger, does he have a gun to his head? I could give you probably 20 examples of cases I've had where it wasn't an issue of imminent danger necessarily. A mother.
I'm just talking about this case, though.
I understand, and just to make it clear, I could give examples, but I won't unless you say it's okay.
Well,
But
let me ask it this way: what fact, if any, indicated to you that Jason Rodriguez, at any point on November 6, 2009, thought he was in imminent danger? Was there any fact in this case that indicated imminent danger to him?
I mean, you're using that term as if there was one specific thing that happened, like somebody threatened him with a gun and he felt necessary to shoot the people he shot. And what I'm saying is I think it's each person's decision. When we say, if the delusional system were true, does it justify the act? What would everybody else do? If they felt like they were being persecuted and brain hacked and my thoughts are being controlled and my family's being harmed and I'm being harmed and they're going to kill me, please help, I think that everybody may do it differently, but what we could point to is he was requesting help, he was seeking help, and there was no response and no help.
But in reference to the day that this occurred, because sanity, you said, is an issue at the time of the offense, correct?
Yes, but you know, I'm not
And the
trying
time
to
of the offense,
Should I ask if you're allowed to finish the answer?
Doctor, did you finish your answer?
sorry, I apologize.
No, that's okay. At the time of the offense, yes, but that does not mean that things, his thinking and the witness statements and other things that were happening leading up to the offense and after the offense are not relevant. That offers a great deal of relevance about his thinking at the time. But, you know, again, I don't have anything about Mr. Rodriguez for 4 months, July essentially until November, aside from what his mother told me in terms of his thinking. So I can reconstruct it as best I can based on the information I can get from other sources, but and ultimately it leads me to the position that the delusional system was active, that he perceived serious persecution to the point of my livelihood, my life, and my family's life are in danger, and that was the motive for the case.
But he couldn't tell you what his thinking was when he entered the offices of RS and H, correct?
That's correct.
Or wouldn't tell you?
Well, that's correct. It could be a wouldn't or a couldn't. The issue when individuals become psychotic and we get them stable, sometimes it's very difficult for them to tell us what they were thinking because they're not thinking in a linear way. When somebody's psychotic, it's not rational, it's not linear. There's all kinds of things that they are contemplating, and it's a little bit scattered. Other people are able to tell you exactly what they're thinking, so there's no absolute on that issue either. With Mr. Rodriguez, he either could not because He just can't remember, or he would not. And I don't know which it is.
Another place to look for what he was thinking at the offices of RS&H would be people who observed him there. Would you agree with that? His actions.
I've thought about that, and I don't know how, unless there were verbalizations associated with the actions. I don't know how shooting in the office building is going to give me much information about what he was thinking and whether it was delusionally based.
Well, it might give you some indication of what his actual motivation was.
Well, motivation, perhaps. Is he targeting specific people?
Correct.
Exactly, and then the question becomes, well, if he's targeting specific people, does that mean he wasn't delusional, or could he still be delusional in targeting specific people?
Well, let's go with what he told you. He told you that Rafael Velasquez was responsible for most of this.
Well,
at least starting it.
Yes, except it's not just him telling me that. That was present in the records, so that was something that was a strong component in this, in terms of weight in the sanity issue. So that's not just what he told me, it was in the records.
And I believe you indicated that you weren't, did you say that you weren't sure if they had face-to-face contact, they being Jason Rodriguez and Rafael Velasquez?
You mean since the shooting?
No, during the shooting, I apologize. Or do you recall?
They did not have face-to-face contact during the shooting.
And do you recall why?
I don't think Mr. Velasquez was there.
Okay. What if he was there? Would that change your thinking? And I say that because the records and Jason Rodriguez said that he was one of the sources. He was the named source, correct?
Yes.
And what if he just walked right by his cubicle? Would that affect your thinking as to his motivation?
I don't think so. I mean, I think, let me be clear, too, that he told me about, Mr. Rodriguez told me about Velasquez being responsible for the delusional system beginning. Mr. Rodriguez also said Mr. Velasquez was responsible for the delusions beginning before the RS&H incident. So this was a long-standing thing. I don't know, because was his motive different? Does that mean that he wasn't specifically targeting Mr. Velasquez? I'm not really sure what you're asking.
You indicated earlier that it is your belief and the basis of your opinion that he went to RS&H to eliminate this threat to his life, right?
Correct.
And he and the records indicated to you that Mr. Velasquez was the source, the named source in that building at the time, correct?
Correct.
So if he didn't look for Rafael Velasquez at all, it might indicate that that was not the reason he went there. In other words, it was not there in self-defense. It was something else.
I mean, in my own thinking, I think that none of us can know exactly what he was thinking.
I agree with that, and you've made that clear.
Yeah, so
that you're inferring all along.
Right.
I understand.
Right. And it's necessary in these kind of evaluations, and it's not just specific to this one. But I think the probability is much higher that, in spite of the fact that he didn't, as you said, look for, or he walked right by Mr. Velasquez's cubicle, this was not just about Mr. Velasquez. It was about RS&H. It was about they destroying my life. It was about co-workers doing this. So the motivation for me was elimination of the threat, which was the entire RS&H entity contributing to the things that were happening in his life and his own perception, when in fact, again, there was no indication that he was in contact with anybody from RS&H for over 2 years.
Doctor, if the jury were to find as fact that Jason Rodriguez shot the people at RS&H out of anger, and not because of his delusion that he was defending himself, would your opinion be that he was legally sane at the time?
Well,
Objection sustained. Rephrase your question.
Would your opinion on Jason Rodriguez's sanity at the time of this offense change if this jury were to find that the defendant shot 6 people in that office out of anger and not because he was going to defend himself from this all-perceiving threat?
Objection. Improper.
Sustained.
Can we approach, Your Honor?
Yeah.
Ask one more way. Would your opinion as to Jason Rodriguez's sanity change if he went to that office to shoot out of anger rather than defending himself from a delusion?
Okay, this just anger, that's not, these aren't mutually exclusive things, first of all. Somebody can be delusional and still be angry. You know, space aliens are coming, and my neighbor knows they're coming, and I'm really angry about it, and I shoot my neighbor. So anger can still be a component of it. Now, it may be helpful if I say if the motive is determined to be simply anger and not based in a delusional system, then yes, that would change my opinion.
No further questions, Your Honor.
Redirect.
Dr. Pritchard, if you can't tell what somebody's thinking at the time, how does an expert make an opinion on sanity ever? How do you do your job?
I mean, rarely is it easy in this kind of circumstance when you're trying to reconstruct thinking at the time. How you do it is you ask the person. Sometimes they're very helpful and sometimes they're not helpful at all. You ask the players that were involved in the ultimate behavior, who saw him in closest proximity to that event, that can contribute some information, who saw him in closest proximity to the event afterwards, post-offense behavior, what was his behavior like. So all those things can give us an idea of what contributed to the behavior, because often, you know, you just can't pull it out from the individual. It's just not possible.
And in Mr. Rodriguez's descriptions about the delusion and the conspiracies and the brain hacking and the gang stalking, didn't he feel that his life was pretty much in danger majority of the time?
Well, that's my opinion, yes. I mean, the behavior is that this wasn't an isolated thing, that all of a sudden he was feeling this way. He was feeling this way for a long time, and he was expressing that he was feeling this way for a long time. So, you know, he's speeding in his car, he's ripping out the interior of his car, he's making holes in the ceiling at his apartment because he's being surveilled and people are watching him and monitoring him, and please help FBI. Yeah, I think that's the indication, is that he perceived persecution, harassment, stalking, threat to the point that he felt his life and the lives of his loved ones were in danger.
And you talked about some evidence, I believe, magazines never found, things like that.
Yes.
Yet, when Mr. Rodriguez went to RSNH that day, there was no hat he was wearing that you observed or read about?
Correct. That was a curious aspect of the case, because again, when I referenced that hiding of evidence is indication of wrongfulness, understanding wrongfulness, typically. So in Mr. Rodriguez's case, you wonder where the vest went, you wonder where the magazines went, and it seems like he's hiding evidence. But on the other hand, he's not wearing a mask. You know, Miss Daly, Mr. Natalie, Mr. Brockman, Miss Natalie Rodriguez, Miss DeClaire, Mr. Beverly, these are all people at RSNH that saw him come in and shoot. So he's not hiding his identity. So what good does it do to hide a vest or destroy evidence or whatever if you're not going to hide your identity? I mean, you're getting rid of a vest, so what? Everybody at RSNH saw who the shooter was, so it doesn't help him get away with the crime. The same goes for the gun. That was an interesting thing. The magazines aren't present. There's 20 shell casings from the fired rounds at RSNH. What do they compare the shell casings to determine, you know, where they came from? They compare it to the firearms. So Mr. Rodriguez does not get rid of the firearm. It's in plain view at his mother's apartment when SWAT team get there. So all that they had to do is match the bullets at the scene to the firearm in Mr. Rodriguez's apartment, and they knew that this was the gun that shot the people at RSNH. So you hide the magazines. How rational is that? That has no value for hiding the crime. They don't compare the shell casings with the magazine. They compare it with the gun. So if you're going to hide it, throw away the gun, not the magazines. So that's the kind of thing. How rational is it to hide a vest? He had 6 or 7 people who identified him. So why would you hide a vest?
And
so that's kind of the issue that I, you know, was sorting out later, is that it's not rational. If he's trying to get away with the crime, then why keep the gun in plain view for SWAT to find, and why not conceal your identity when you go into RSNH?
And that goes to the wrongfulness.
Goes to the wrongfulness, and you know, and how many video cameras did they have with his picture on it in the elevator and in the parking garage and on the floor? So he's not concealing anything. So to hide, if in fact he hid evidence, we don't know that. We just know that there's some missing. Why in the world would he do that?
And is it curious as to the wrongfulness that he didn't flee? He didn't try to go on a high-speed car chase. He didn't try to go to a different state. He didn't take an airplane out of town. He went home and ate.
Extremely relevant, because if you're trying to hide, you're trying to get away, you don't go home where they can find you. And, you know, so yes, it suggests that it wasn't a rational thing. It was not something that he was trying to hide from, and in fact he didn't. He was at home and they found him easily.
Now, you talked about on cross the statements that he made of either "I'm sorry," which could suggest that he might know wrong.
Right.
But does that suggest that he knew wrong when he made the statements, or does that suggest that he knew wrong when the shooting happened?
Yeah, I mean, that's a hard one. But his own version is that he went home and was watching himself on TV. So the possibility is, and I don't know this for sure, but the possibility is...
Sustained.
In your opinion, if he's at home watching himself on TV, what does that tell you about his statements of "I'm sorry" or...
Well, maybe that's when the recognition hit, is when he's watching himself on TV and he's the sought-after guy, and still he doesn't flee, but he says sorry when SWAT team comes. But he also says something like, this whole thing will work itself out, which you're sorry, maybe some tacit suggestion that he recognized the wrongfulness, this whole thing will work itself out. I mean, that to me sounds like it's still, it's delusional thinking or that's generating that comment. So, you know, again, these cases, you have information that's going to weigh on one side and information that's going to weigh on the other. And it was outlined in my report and here in court today about the things that weighed on the side of culpability remaining with Mr. Rodriguez, and then information that's weighing on the side of culpability not remaining with him, and it's much heavier on that side. It's a very complicated case, yes, and it's hard to wade through all this and see the information and come to an ultimate decision, but my ultimate decision is that there's a lot more that weighs on the side of culpability not remaining with him.
And when you say culpability not remaining with him, what does that mean? What do you mean by that?
It's that he had a mental disease, infirmity, or defect, and didn't understand what he was doing was wrong.
Okay, so the majority of what you've seen weighs heavier towards that.
Yes.
Okay. Now, when we were talking about the mom, you said, you know, we've all heard family members can't be most reliable, but you found her to be reliable.
I mean, you know, I can't know that every single thing she told me was true, was honest. I can't know that. What I do know is when I asked her...
Sustained.
May we approach?
You may.
Thank you.
Objection sustained.
Does anything about the time period between, I believe you said June or July of 2009 up until November of 2009, were there a lack of record? Does that suggest that maybe he wasn't receiving treatment during that time period?
It suggested it to me, yes. I mean, we had some notes from some treatment he was receiving in Greater Orlando Psychiatric Association, and there were no notes from that period of time, so the suggestion was that he wasn't getting treatment.
Okay. All right. Thank you.
Any additional questions on that area?
No, Your Honor.
May Dr. Pritchard be excused?
Yes.
Thank you, Doctor. You may be excused.
Thank you, Your Honor.
The defense may call the next witness.
Thank you. Dr. Danzinger?
Dr. Danzinger?
Just tell me sir, the testimony you should give should be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
You may proceed.
Could you please state your name and spell your last name for the record?
Jeffrey A. Danziger, Danziger.
And Dr. Danzinger, where do you work?
I work in Maitland. I am a psychiatrist.
And could you tell us a little bit about your educational background?
After graduating from high school in Dade County, I attended Harvard College in Cambridge, Massachusetts, and graduated from Harvard magna cum laude with a bachelor's degree in biology in 1978. I then came back to Florida to the University of Miami School of Medicine, and I achieved my MD in 1982. After graduating medical school, I went to St. Louis, Missouri, to the Washington University School of Medicine, where I did my internship and residency in the field of psychiatry. I finished my residency in psychiatry in 1986. I then spent 1 year on the faculty of the medical school, and in 1987 came to Central Florida. And I've been in the Orlando area since 1987, so for 26 years now. I am board certified in general psychiatry, addiction psychiatry, forensic psychiatry, and in geriatric psychiatry. I have an office practice in Maitland, right off exit 90 off of I-4, and I do have a patient practice. I see people essentially age 15 up into their 90s for a variety of psychiatric conditions: depression, bipolar disorder, schizophrenia, panic disorder, anxiety disorder, a host of different psychiatric conditions where I'm the treating doctor. I also spend one afternoon a week doing psychiatric research. I serve as a principal investigator on a number of studies. Most of these are new medications not yet out on the market. And my role as a principal investigator is to be sure that the protocol is followed and make sure that the patients are well cared for and safe. And the third hat, or the third leg of what I do for a living, is what I'm here today. And that is, as a forensic psychiatrist, I'm not in a treatment role today, but I'm offering opinions about a legal case in a legal setting. So I treat patients, do research, and do what I'm doing here today. And I've been in town here now for 26 years.
And are you on a court-approved list to do these evaluations for sanity?
Yes, I am.
And do you have to take a course in order to get on that list?
Yes, I took that course quite a few years ago, but yes, I did.
Do you recall who teaches that course? Do you perform evaluations for sanity?
Yes, I do.
And do you know over your career how many you have done?
I don't have an exact number. I've started doing them in 1988, so several thousand. I don't have an exact number.
Okay. And do you work for all parties, meaning the defense, the court, the state?
Over the years, yes. Over the years, many times the court or the judge has asked me to evaluate someone, defense attorneys, both public defenders and private attorneys. Sometimes the state attorney's office, the government, has asked me to evaluate people in rebuttal. So over the years, yes, I've worked with everybody.
And you said if the judge appoints you or asks you, what does that mean?
Sometimes it's neither the defense nor the prosecution that asks me, but the court will issue an order. The judge will issue an order asking me and perhaps other doctors to evaluate someone and report back. And in a matter of sanity, that means I simply give my opinion. The court, the judge, is the one who has appointed me, so I'm beholden to neither side.
And that's referred to as court-appointed?
Yes.
Now, in this particular case, you were hired by the defense, is that correct?
That is correct.
And you were paid to conduct an evaluation and write a report?
Yes.
Have you ever testified as an expert in court before?
Oh, yes.
How many times?
Perhaps 400 odd times, something in that ballpark.
Are you licensed in the state of Florida?
Yes, I am. I'm a medical doctor, and I do have a license in the state.
And when you say medical doctor and a psychiatrist, how do those two coincide?
Psychiatry is a specialty of medicine. To be a psychiatrist, one must be a medical doctor, either an MD or a DO, a doctor of osteopathy. I have an MD, I'm a medical doctor, and my license in Florida says I'm a medical doctor. Now, even though I'm a medical doctor, I don't take appendixes out. I don't do surgery. I don't deliver babies. I'm a medical doctor who practices the field of psychiatry.
This time I'd ask that Dr. Danzinger be qualified as an expert in the area of forensic psychiatry and be able to give his opinion as such.
What says the state? Ladies and gentlemen of the jury, Dr. Danzinger will be accepted as an expert witness in the area of forensic psychiatry. You may continue.
Thank you. Did you have an occasion to evaluate a man by the name of Jason Rodriguez?
Yes, I did.
And do you recognize Mr. Rodriguez in the courtroom?
I do indeed.
And could you point him out and say what he's wearing?
He's sitting there next to Ms. Klossner at the defense table. He is in a white shirt, has a gray beard.
Would the record reflect that he's been identified?
The record would so indicate.
Thank you. And how many times did you see Mr. Rodriguez for the purposes of sanity, talking to him about sanity or what happened at the time of the offense?
I know on July 28, 2013 I did, and there was also some discussion as to that on October 27, 2013.
Okay. Was there any other time that you saw him where you discussed the facts of the case at the time of the offense?
Yes, on November 15, 2009.
And overall, in regards to asking or talking with Mr. Rodriguez about sanity, time of the offense issues, about how much time do you think you spent overall?
It's hard to separate that out from past history and past psychiatric history, but perhaps an hour and a half, 2 hours just on that issue alone.
Okay. Did you also spend time reviewing other records or data, paper that you received?
Yes, that's what this is here. These are records and documents that I reviewed that pertain to this matter.
And could you tell us what you reviewed as far as sanity goes for this case?
Okay, it's a fairly long list.
That's okay.
I reviewed the police reports from November 6, 2009, which describe what took place, how he ultimately was apprehended and taken into custody.
Does that have specific quotations from people in that police report?
Yes, it does. There are references to statements made by James Beverly, Keith Brockman, Maureen Daly, Jesse Forst. Police also spoke to Rafael Velasquez, and there were transcripts of these conversations that I reviewed.
Okay. I'm sorry. Go ahead with your list.
I also reviewed the Orange County Jail medical record file, and of particular interest were notations very close in time to his arrest to try to shed light on his mental state at that time. I reviewed the indictment. I reviewed records from Greater Orlando Psychiatric from 2003, 2004, then 2007. There were some emails that I reviewed. I reviewed some other police reports that are not directly tied to this case, but they are from June 29, 2007, August 24, 2007, and September 22, 2009. I also reviewed reports of multiple other doctors, including Dr. Olander, Dr. Otto, Dr. Hall, Dr. Burns, Dr. Mings, Dr. Pritchard. There was a surveillance video that I viewed from November 6, 2009, covering a period of time from about 11:30 to just before noon. There were some records from Lakeside, which is our local community mental health center. Those records are from 2007. There was a statement that it was fairly brief, about 6 pages long, but a transcript of a statement that Mr. Rodriguez gave to police shortly after his arrest. Then there are also some videos of jail visits that had little information. So that essentially was the data that I reviewed.
And did you conduct any interviews with anyone else regarding this case?
I spoke to his mother, Anna Rodriguez. That phone call I made, it was on the telephone. That was in October 10th, 2013. So I did speak to his mother to garner some additional information.
And I want to move you now into sanity. In Florida, what is your understanding as the test for sanity?
The test for sanity in Florida is very close to what's called the Monotone rule. And someone must first have some mental disease. It requires that someone first have some mental disease or defect, and by virtue of that mental disease or defect, they're either unable to know what they are doing and its consequences, or unable to know that the specific act is wrong.
So let's go to the first prong, which is, does the person have a mental disease, defect, or disorder? Did you find that Mr. Rodriguez has, at the time of the offense, a mental disease, defect, or disorder?
Yes, I did.
And what was that?
It is my opinion that he suffers from schizophrenia.
And what gives you that conclusion, that he suffers from paranoid schizophrenia?
There are many factors that cause me to reach the diagnosis of schizophrenia. We know from looking at other records that there is evidence of mental illness that predates the offense. One of the things about schizophrenia is that it's not something that comes and goes suddenly. Our criteria require that the symptoms must be present for at least 6 months, but for most people it is a lifelong diagnosis that starts either in early or middle adulthood and carries on over a period of years. We have the records from Greater Orlando Psychiatric showing that in 2007 he was evidencing paranoid delusions, believing that he was being persecuted and stalked. I reviewed records from Lakeside, and those records from Lakeside show that in 2007, he was Baker Acted by police. A Baker Act means you are taken against your will to a psychiatric hospital. He was walking in traffic, apparently acting oddly, hospitalized at Lakeside, where they thought he was paranoid, responding to internal stimuli. What that means is they believed he was hearing or seeing things from the outside, and he was hospitalized. So we have data to show that this is someone who had symptoms of mental illness that predate the offense. I looked at the statement of Mr. Rafael Velasquez, who said that he was a co-worker and that Jason Rodriguez was carrying papers around, saying somehow that agents might be following him. So there was evidence that he was acting oddly, seemingly paranoid. In speaking to his mother, the mother gave me very useful information that Jason had been hiding in the laundry room, ducking down for fear that he might be watched or harmed, that he was cutting matches in half and putting them in the popcorn ceiling to try to block out the cameras or the fiber optics, that he had been knocking holes in the walls, ostensibly to try to find the speakers. So there was data to show that before the offense that there were symptoms of mental illness. One of the things we know about mental illness, it is not something that comes and goes suddenly. Unless someone's intoxicated on substances, they can be very ill for brief periods. But an illness like schizophrenia persists. After his arrest, jail mental health personnel described paranoia, described abnormal behavior, and then we know that he went to the North Florida Evaluation and Treatment Center, which is a psychiatric hospital in Gainesville, and while there, those doctors diagnosed him with schizophrenia and described symptoms of mental illness. What we have is someone with symptoms of mental illness that predate the offense and then continue after the offense. in looking at schizophrenia, it is a serious mental illness. To be diagnosed with
Sustained.
Could you explain to the jury a little bit more about schizophrenia and how it affects someone?
Schizophrenia is a serious mental illness. Someone must have
Overall, but let's get to the point. It can get cumulative. Overall,
Schizophrenia is a serious mental illness. Individuals must have psychotic symptoms, which would be delusions, firmly held false fixed beliefs, hallucinations, which are false sensory inputs, or disorganized flow of thought. The symptoms must persist for at least 6 months. They must cause serious interference with people's social, occupational, or other important areas of functioning, and it often leads to a deterioration of personality and a downward course in an individual's social and family life.
Now, getting back to the definition of sanity, I want to go and talk about the second prong of it. Under number 2, the first part is because of the condition. In your opinion, did he know what he was doing or its consequences on that day?
In my opinion, yes.
And go to part B, which is or, although he knew what he was doing, which you say you do, and its consequences, which you says he does, did he know it was wrong?
In my opinion, because of his mental illness, he was unable to know what he was doing was wrong.
Why?
It's my opinion that at the time of the offense, he was in an entirely delusional and paranoid state of mind. He was hearing the voice of Sharptooth telling him that he would be killed at any time, believed that there were plots and conspiracies from his former employers, that he was being brain hacked, and that the goal was to humiliate and embarrass him before ultimately killing him, either with some sort of a saw or tree trimmer. His actions suggest someone who believed he was in danger of being killed at any time. It is my opinion that his thinking at the time was so distorted, so delusional, so paranoid, that he saw nothing wrong in what he did, but rather was defending himself from the source of his torment and the people who were attempting to first humiliate him, impoverish him so he could not sustain himself, and then ultimately violently kill him. My opinion is that because of his mental illness, he did not know what he was doing was wrong.
Now, is it your opinion that Mr. Rodriguez felt he was being threatened or in danger pretty much all the time?
Yes, based on the information that I have, yes.
And could you just give us some specifics that leads you to that conclusion?
Mr. Rodriguez reported that he was keeping a gun with him at all times for fear that he might be attacked at any moment. He reportedly was hiding in his house, pulling the car over and ducking down. These are the sorts of things that describe someone who believes that he is in a state of danger and could be harmed at any time, and they are consistent with someone suffering from severe paranoid delusions with a diagnosis of schizophrenia.
Now, are all people with schizophrenia insane at the time of the offense?
No.
So what makes Mr. Rodriguez's situation different?
In each case, as a forensic psychiatrist evaluating these matters, I have to look at the specific situation, and then I offer my opinions to lawyers, judges, and juries. In this particular case, my opinion is that this is someone who was severely ill, believed he was in danger at any moment, was being tormented and plotted against, and acted against his tormentors, whom he believed could kill him at any time. That is why, in my opinion, this rises to the level of insanity, that he did not understand or know the wrongfulness of his conduct because of his delusional state.
Well, did you see the comments that Mr. Rodriguez made to either the media or the police after the shooting?
Yes.
And does that conflict at all with your opinion on him knowing the wrongfulness?
It does not.
Why?
He said I believe he said to the media, they just left me to rot, which would be consistent with his belief that he was simply being humiliated and impoverished before being killed. It would be consistent. He said to Officer Jonathan Cute, one of the SWAT team officers took him into custody, I'm just going through a bad time. This whole thing will work itself out. This is someone who had just shot and killed someone, wounded 5 others. His saying this whole thing will work itself out seems entirely implausible. He said to Officer Easterling, I'm just going through a rough time right now. I'm sorry. Well, he did say he was sorry. This is someone who did not seem to understand the gravity of the situation, the wrongfulness of it, who simply went home and cooked himself a meal. This is just someone who simply did not understand he might be the subject of a manhunt, who had just committed this awful act. Rather, his comments to media and police immediately at the time of his arrest suggest something who had no understanding of the wrongfulness or gravity of what had taken place.
Even though he says, I'm sorry.
Yes.
So how do you weigh that out with the fact that he says, I'm sorry, yet still doesn't understand the wrongfulness?
I don't see it as inconsistent. I simply see it, if you look at the entire context here, someone who simply did not comprehend the wrongfulness of the situation, may have been apologizing for the police having to be there, but when you look at the entire context, this is not someone who fled the scene, tried to avoid being captured, barricaded himself in the home, just sort of held his hands up, got down on the ground, peacefully went out, and seemed surprised that the police were there in the first place.
Now, are you aware of when the first moment was that Mr. Rodriguez realized that he had been involved in the shooting?
What he told me was that he saw something on television.
Okay. And that's when he realized?
That is what I recall him telling me, yes.
Okay. So, in your overall opinion, does Mr. Rodriguez meet the criteria for insanity at the time of the offense?
In my opinion, yes, he does.
Thank you.
Cross-examination.
Good afternoon, Mr. Enberg.
Thank you. Good afternoon to you. I am going to do my best to get to the point. All right? But I have to cover some preliminary matters, including the fact that you gave a deposition to me, did you not, on September 24th of 2013.
Yes, I have a copy of it here.
Good. Yet, you say that you continued to evaluate the case after that time and meet with Mr. Rodriguez.
Yes.
Did you disclose that matter?
Counsel was aware, and I was supplied with additional data.
Which counsel?
Ms. Vickers. She's the one who sent me the additional data.
Okay. Did you somehow document that after you and I spoke that you did additional work?
Did I document to you? No. Did I tell Ms. Vickers? Was she aware? Did she send me data? Yes.
Okay. Well, at the time of your deposition, a point in time where you had already rendered a report and reached a conclusion, you had not spoken with Mr. Rodriguez's mother, correct?
Correct.
You had not viewed a single videotape, whether that be of the defendant's statement, the media shouting anything to Mr. Rodriguez, the events that were captured by surveillance at the Gateway Center. So all of this work that you did was after you already wrote a report expressing your opinion on Mr. Rodriguez's sanity, correct?
Yes, that's correct.
Okay. So let's go to what Mr. Rodriguez actually did tell you. Did he tell you he couldn't remember certain aspects of what had occurred?
Yes, he did.
Is there anything in Mr. Rodriguez's history documented anywhere that amnesia is some sort of symptom of his paranoid schizophrenia?
There's no other references to that.
Okay. So as far as you know, his amnesia from the point in time he started shooting until he got home and was cooking himself a meal is the first time documented anywhere that he said he can't remember anything attributable to his mental illness or otherwise.
I don't recall any other episodes of amnesia in his history. That would be correct.
Okay. So you saw him pretty early on.
Yes, 9 days after the offense.
Right. And he had already been in the Orange County Jail, and they were documenting their observations of his behavior on a daily basis.
Yes.
And one of the first things you wanted, at least from him at that point, was to see how much he did recall or how much he would be willing to relate about what happened.
Yes.
Okay. So you ask him, pretty simply, what occurred.
Yes.
And one of the first things out of his mouth was that he went to this post office box and there was no unemployment check there, correct?
I'm looking to see if he said that during the first meeting. I'm looking at my original notes. Because you're asking about November 2009 now, not any later meetings. Is
Correct.
that correct? I'm looking at my original notes from November 2009, and the issue of going to the mailbox was not at that. That was at the July 2013 meeting where he related that to me.
All right, so why don't you tell me where it was that Mr. Rodriguez told you that after he went to the post office and there was no unemployment check there, he said, enough is enough, they needed to provide me with unemployment, there was no check, they were being pricks, I'm not going to get my check.
That would have been in my July 2013 meeting with him.
All right, so most recently, well, I guess you met with him after I talked to you, but the most recent point in time before the deposition, when you asked him why he went there, he said because he wasn't getting his check.
Yes, I'm looking at page 12 of my report. That's the reference.
All right. He did not at that time mention to you that he went there to silence Sharptooth, correct?
He did not say that to me.
In fact, Sharptooth was not something that was even mentioned to you going back to November of 2009 when he saw you, correct? When you saw him.
He did not use the word Sharptooth, He did make reference in that first report to audiology and odd things, but he did not say the words Sharptooth.
And at no point in time, regardless of when you spoke to him, did he mention that Sharptooth was at the building where the shooting took place, correct?
He did not mention that to me.
In fact, when we met, you indicated to me that based on your interviews of Mr. Rodriguez to that day, you were not arguing in his defense that he had acted out of some sort of delusional self-defense, correct?
Correct.
It was your argument that he believed that his actions were justified,
Yes.
that these people, they, were ruining his life financially, correct?
Yes.
Socially,
Not sure if I used the word socially.
Okay.
I'd have to look at the deposition.
mostly financially. He was unable to get or hold a job because of things that they were doing or saying.
Though I'm looking at the deposition itself, if you want me to refer to that in answer to your question. And essentially what I said, and I'll just quote from page 48, this was a severely mentally ill man, believing that wicked people were conspiring against him, seeking to humiliate him, impoverish him, and then ultimately kill him. And then in the next paragraph, I say that in his actively mentally ill state, he believed with regard to that specific action that his actions were proper and justified because of his delusional state. And then on the next page, I go about why I believe that he did not believe his actions were wrong. So I'm just referring to the deposition itself.
All right. So do you consider that Mr. Rodriguez's actions were a preemptive strike against those who would someday harm him in the future?
I'm thinking about those phrases. I would say, in keeping with what I said in the deposition, he was not of the opinion at that moment that he was in danger at that second. So likely the harm would come at some point in the future, although it could come at any time.
So your answer then would be yes. Based on what he told you and your evaluation of him, his actions at RS&H were if you were to believe that his delusions were true, a preemptive strike against people who might harm him at some point in the future.
And I'd phrase it differently in that he did not use the words preemptive strike.
Those are my words.
Right.
I
They
admit
were.
that, but it's the same concept. Was he trying to prevent future harm as opposed to immediate danger?
And I'll answer it this way as best as I can. He was, at least what he told me, I can't experience the voices, hearing voices that he could be killed at any time by a tree trimmer, by being chopped up. So his concern was that while it was not going to happen at that second, it could happen at any moment, not at some indistinct point, months or years hence, but that the danger could strike him at any moment. So I would phrase it that way.
Did he tell you that some tree trimmer appeared to him at the offices of RS&H?
Oh, no.
Did he
No.
tell you that any threat appeared to him at the offices of RS&H?
He did not.
Do you have sufficient grasp of the facts of what occurred on that floor?
Yes, I believe that I do.
Do you know that when Mr. Rodriguez entered into the offices of RS&H, his demeanor from the time that he entered to the time that he first fired a shot and as he maneuvered throughout the building did not change?
I know that nobody heard him say anything. As far as was he silent? Did anybody hear a statement? Yes. As far as his demeanor the entire time, I'm not sure that anyone witnessed him and watched him the entire time. The witnesses that I read were basically hiding, ducking, leaving the area, so I'm not sure that anybody sat and coolly observed his demeanor the entire time.
All right. Do you believe that when he opened the door to those offices that he was defending himself from imminent harm?
It's a difficult question to answer because you're asking me to apply the standards of a sane person to a paranoid and psychotic one. And while I'm not a prosecutor, I understand, or lawyer, I understand there are times when deadly force can be justified. If you believe you are in danger, it can't retreat. I don't know the specifics, but I understand the law does allow it. But this is not a well man who can appreciate the situation rationally. This is someone who is severely ill, paranoid, hearing voices, believing in a vast conspiracy, who acted in response to that delusional belief. So I can't apply the standards of a sane man to this severely mentally ill one.
Well, then let me ask you this. Are you familiar with the law that states that the guilt of a person suffering from hallucinations or delusions
Approach. Ladies and gentlemen of the jury, there are going to be some brief matters we need to take up outside of your presence. This would be a good time for you to take your afternoon recess. We will be back with you as soon as possible.
May be seated.
You can have your copy back.
Yes, sir.
Doctor, you can stand down. Step up.
Thank you, Your Honor.
It'll be a while. me hear arguments from both sides.
Would you like me to start or defense?
You can start.
Right. Your Honor, the instruction that the defense refers to, that at the top says that should not be given after a certain point in time in the year 2000, does not negate the fact that the state of the law, as it relates to how a jury should weigh evidence dealing with hallucinations and delusions in the context of insanity, is something that still shouldn't be part of any instruction to the jury. The case, Cruz versus State at 588 Southern 2nd 983, still does talk about the fact that just because an instruction has been dropped or changed does not mean that the court cannot give it, or that the court is only required to give those instructions that are contained within the standards. If it is an accurate reflection of the law and can assist the jury in determining the facts at issue and how to apply those facts to the law, it should be given. These doctors throughout have testified that the reason why Mr. Rodriguez acted as he did was because he was suffering from particular delusions that led him to believe that there was a conspiracy against him that was going to cause him harm. So the jury should be appropriately instructed, and then as a corollary, I should be permitted to ask the question of the expert that if this is the law.
What case still says that still establishes the principle of the delusion instruction being allowed in the state of Florida?
I don't know that there is a case. I tried to determine whether or not Cruz has been overruled, and it has not. It's not been changed, modified in any way. When you look at the law that we discussed as it relates to the burden of proof, it doesn't touch this issue.
Well, the only thing I see, and I haven't finished doing everything that I'm going to do, what it's concerned is guilt offenses only occurring before June 19th, 2000, see section 775027.
That's the section that we examined the other day that talks about the burden of proof in an insanity case. It makes no mention of a change in any way to how the law is applied to situations involving hallucinations and delusions.
I'll find out in a minute, folks. Let me hear from the. You can finish your time.
That's my argument to this point.
Okay.
775.027 talks about the insanity defense. Number one is the affirmative defense, which is basically what the jury instruction on insanity tracks. Talks about the different prongs and mental harmony, and because of the condition, did they know what they were doing? Did they know what was wrong? Part two of that is the burden of proof on that. Nowhere does it talk about hallucinations. In fact, when the hallucination instruction says, see section 775.027, and it discusses give only for cases occurring before June 19th of 2000, it's because this instruction added by laws in 2000 effective June 19th of 2000, meaning that they took that out of the statute of the actual law June 19th of 2000, which is why it should not be given. Second of all, I think it's untimely. We tried to raise jury instructions early on. We have not prepared the case for an instruction on delusion and hallucinations with the understanding that it is no longer good. The only statute in here discusses the one insanity instruction, which is the 3.6a, which is the only one. It discusses in the statute.
Your Honor, your argument as to timeliness is inaccurate.
Timeliness, that charge conference is a charge conference. You have up until the time that we finish your charge conference to request instructions. Going to the next one.
But I did put them on notice that I would be asking for this depending on the evidence that comes out.
Anything else from the other side?
Yes, Your Honor. I think that the June 19th of 2000 inaction of this effectively overturns Cruz on the in-ray standard jury instructions in criminal cases on September 28th of 2006 that the state actually provided early on when we were debating the whole burden of proof as to sanity. Again, it talks about give the insanity hallucinations given only for offenses occurring before June 19th of 2000. And then again, it just says refer back to the statute, meaning that, and if you refer back to the statute, there's nothing in there about hallucinations. So are we to properly give it and be able to allow a question on it?
Your Honor, the jury is not going to know how to evaluate this case within the framework of what has been presented to them. How do you evaluate hallucinations and delusions as part of someone's defense? The Florida Supreme Court has already given us that guidance. So how do we not let them know ahead of time how to evaluate the facts that have been presented to them in the context of what is still the law, despite changes in the jury instruction?
You keep saying what the law is, but what I'm trying to find out, and which I have not found, is a case or a statute that speaks as to what is the law dealing with delusions. The perplexing thing about it, when it makes reference to looking at the statute, if you look at the old instruction versus the new instruction, they spend a great deal of time talking about the shifting of the burden of proof, which was erased. It's an affirmative defense, so that burden is solely on the defense. What I'm trying to get to, in which, to be frank, y'all are not being too helpful, is the basis of this instruction. And that's what I'm trying to get to, is generally, in cases when there's an instruction that comes out, it is based upon a case or a point of law.
Well, the language of the old instruction is identical to the language in Cruz.
I'm not interested in the language. I'm interested in a case that establishes that as a point of law. And that's what I'm trying to find.
I looked for other cases that interpreted this standard, and I did not find them. So it's not that I'm intentionally not trying to be helpful.
I did not say that anybody intentionally did anything. I'm just saying what y'all are telling me right now is not helping me. We'll take a recess. Let me go back to my office and some things